Start. I have considered the submissions raised by learned counsel for the parties and perused the record. The sole contention of the petitioner is that the complainants who are not the aggrieved, as they are not card holders, therefore having no locus standi to file complaint. Petitioner has taken specific ground before the respondent numbers 2 and 3 and also before this court. But the respondent numbers 2 and 3 have not returned any finding, even not a single word, and straightway cancelled the license of fair price shop of the petitioner only on the ground of certain alleged forged affidavits. Once the petitioner has taken ground that the complainants are not the persons aggrieved, it is required on the part of the authorities concerned to first consider the objections raised by petitioner and then pass reasoned order, which is absolutely lacking in the present case. He has taken this specific ground in different paragraphs of the writ petition, but in the counter affidavit there are very vague denial of the substantial facts which amounts to admission. I have also considered the judgments relied upon by learned counsel for the petitioner. In the case of Mahendra Singh Supra, this court has taken clear-cut view that objections and grounds taken before the authorities must be dealt with in impugned order. Paragraph 8 of the said judgment is quoted below. In my opinion, non-consideration of the petitioner's reply in respect of the charges levelled against him amounts to denial of effective opportunity of hearing, which further amounts to breach of principle of natural justice. Therefore, the writ petition is being entertained in view of the law laid down by the Apex Court in Whirlpool Corporation versus Registrar of Trademarks. This court in the matter of Srimati Rita Singh Supra has also taken the same view. Paragraph 10, 11 and 13 of the said judgment are quoted below. It is settled proposition of law that when an explanation is called and explanation is submitted raising certain pleas, the same is liable to be considered by the concerned authority before passing the order, and recording a finding is must, which may indicate the application of mind of the concerned authority and as to how he had come to conclusion, but no such finding or reasons have been recorded by the opposite party number 3. On being challenged in the appeal, the appellate authority has also not recorded any finding in regard to the pleas raised by the petitioner, and without recording any finding, the appellate authority observed that the case law relied by the learned counsel for the petitioner is not applicable. The appellate authority also went a step ahead in recording a finding that the petitioner had not submitted the documents required by the concerned authority, while no such finding was recorded by the opposite party number 3. The appellate authority could have recorded such finding, but only after verifying from the records, and in such a situation, the appellate authority should have recorded a finding as to what documents were submitted by the petitioner. In view of the above, this court is of the considered opinion that the impugned orders have been passed without considering the objections raised by the petitioner as well as the grounds raised in the appeal. Therefore, the same are non-reasoned and non-speaking and without application of mind, hence not sustainable in the eyes of law, and are liable to be quashed, with a direction to the opposite party number 3 to consider and pass a fresh order in accordance with law. This court in the case of Naval Kishore within bracket Supra is of the firm view that only aggrieved person can file complaint. Paragraph 4 and 5 of the said judgment are quoted below. These submissions were denied by counsel for respondent number 5, who submitted that petitioner has no locus standi to prefer the writ petition. He contended that the petitioner was only the complainant on whose complaint inquiry was initiated against respondent number 5. After initiation of the said inquiry, petitioner has no right to interfere either during inquiry or in appeal. He relied upon judgment passed by division bench of this court. The meaning of the expression person aggrieved will have to be ascertained with reference to the purpose and the provisions of the statute. One of the meanings is that person will be held to be aggrieved by a decision if that decision is materially adverse to him. The restricted meaning of the expression requires denial or deprivation of legal rights. The right expression person aggrieved means a person who has suffered a legal grievance, that is, a person against whom a decision has been pronounced which has lawfully deprived him of something or wrongfully refused him something. The petitioner is not an aggrieved person by merely filing a complaint. The order of revocation of cancellation of fair price shop license do not affect him in any manner. In the case of Zakir within bracket Supra, this court is of the same view that only aggrieved person can file complaint. Relevant paragraph of the said judgment is quoted below. In all the three cases referred herein above, court has taken constant view that only aggrieved person who has participated in the process of allotment of fair price shop can file appeal. Any appeal filed by stranger outsider is not maintainable. In present case 2, undisputedly respondent number 5 was never participant in the process of allotment of fair price shop. Therefore, this court is also of the same view that he is not the person aggrieved and cannot file appeal against the order of subdivisional magistrate. It is required on the part of respondent number 2 to consider about the maintainability of appeal and return findings upon the ground taken by the petitioner in reply of appeal. In case it was found that the appellant is not the aggrieved person, appeal has to be rejected on this ground alone. But here, while party allowing the appeal, respondent number 2 has committed error of law as undisputedly appellant was not the person aggrieved. Therefore, impugned order dated 22/8/2017 passed by respondent number 2 is bad and liable to be set aside. The apex court in the matter of M. Venkatraman within bracket Supra is of the considered view that there must be specific and factual denial in the counter affidavit and vague and evasive denial amounts to admission by respondent. Paragraphs 12 and 13 of the said judgment is quoted below. The contract between the parties, moreover, was a contingent contract. It was to have its effect only on payment of the said sum of rupees 15,000 by the plaintiff and other respondents by the defendant numbers 1 to 3. It has been noticed hereinbefore by us that as of fact it was found that no such payment had been made. Even there had been no denial of the assertions made by the appellant in their written statement in that behalf. The said averments would therefore be deemed to be admitted. Order 8 Rule 3 and Order 8 Rule 5 of the Civil Procedure Code read thus.